Sir, if it is possible, then if I'm giving presentation in full screen, then it is fine. It works fine.
तो full screen में दे दो.
Okay,
No,
sir.
no, no,
Okay.
not in full screen. Oh, just one second, sir. I'm presenting. Just one second. Yes, sir. So the topic of our presentation is Adidas versus Forever 21. So, sir, as we know that intellectual property is a very hot topic for businesses of any size, and the intellectual property created by your company is very, very essential for your success. Protecting the intellectual property should be a top priority for the owner. And sir, as you have taught us in class, that trademark is one of the most valuable. In fact, sometimes in some cases, trademark is valuable to the extent where its value is more than all the other IP properties combined. Value of the other IP properties combined by the company that it holds them. So the the point or the trademark that Adidas was fighting with Forever 21 was the three stripes. Right. So Adidas is a German multinational corporation, and its primary business is it's a manufacturer and designs shoes, clothing, and accessories. Where Forever 21 is a fast fashion retailer. It's an American fast fashion retailer based in Los Angeles, California. So Priyanshi, you can take this topic.
The three stripes. Am I audible?
Yes.
Okay. So the three stripes is an Adidas trademark that consists of three parallel lines that appear on the side of the Adidas sportswear. Now, earlier in its history, Adidas was known for its branding, with its founder Adolf Dassler referring to it as a three-stripe corporation. The Finnish Sport Museum has a pair of Karu Sports three-stripe sports shoes from the 1940s. Now, following the summer of 1952, the Summer Olympics in Finland, Adidas bought Karu Sports' iconic three-stripe branding for two bottles of whiskey. Now, since the 1980 Summer Olympics in Moscow, the Adidas three-stripe brand has been the trademark of the Russian Olympics and is a major subject for the hard bath. Now, the Adidas is pretty much everyone who has used.
Sir, Priyanshi, your voice is cracking. Is it cracking to me or everyone?
To everyone. Your connectivity is weak.
I think, sir.
Priyanshi, your
I think
connectivity is very weak.
connectivity is weak. I can explain this slide. Okay.
Okay.
So, sir, the three stripes trademark consists of three parallel lines, and Adidas was well known for branding this in the history, and it's a very interesting history that even the founder of Adidas, the owner of Adidas, described the company as the three stripe company. So this design was essential to Adidas core principles of design, and there are many things that are being said about these three stripes, how it came into picture. So one of them is that Finnish Sport Museum has a pair of footwear in 1940s which had three stripes, and Adidas acquired this from this brand Karu Sports for two bottles of whiskey and $1,600 that were equivalent of $1,600. So they have bought this design from another company that was at a very cheap rate in 1949, and from that point onward, we have seen that Adidas has fought to protect these three stripes from many brands, and there was an open war declared by Adidas on any brand that was even trying at the slightest to use these three stripes. There were many companies apart from Forever 21 that faced the heat from Adidas for using three stripes. So those were Fitness, World Trading, Abercrombie. Okay, so you can read all these Adolf, Steve Madden, Target Corp, and Nordstrom. So next, building the brand. So as we know that Adidas three stripes are very very important for Adidas. But what resources did Adidas put in this trademark that Adidas was trying to protect it? So they build a brand around these three stripes by using it in sports and using it in other cultural things. Some of the things that they resources that they put in sports where they were using it as a national, calling it athletic association uniform. In 24 they were they were fighting and putting complaints over International Olympic Committee for limiting the size of the logo of Adidas to 20 centimeter square on the shirts of the athletes. It also sued England lawn tennis and other club for restricting the manufacturer's identification that is placed on the players' clothing. So they're fighting here and there so that they can build a brand. They're also using it with the cultural artist like Lady Soner. They because they paid her to use it in her song in the album Public Warning, as the stripes, the word three stripes were used in the song Hoodie and all. So these things we can see that Adidas was investing a lot. Coming to the next topic, the ugly fight between Forever and Adidas 21. Sorry, Adidas and Forever 21. Suvidi will explain this. Suvidi?
Yeah, hello, am I audible?
Yeah.
Yes.
Okay, so this started in 2015 when Adidas has originally sued Forever 21 in LA for utilizing the distinctive three strips. And then, Adidas claimed that Forever 21 merchants were likely to cause confusion and deceive the public regarding its source and dilute and tarnish the distinctive quality of the three stripe mark. So Adidas also asked the court to stop Forever 21 from distributing and marketing and selling those clothes that were identical to the three stripe mark. Adidas was also asking for monetary damage, Forever 21 to pay them some monetary damages for the same. So this not only started in 2015, but it was going on since 2006 when Adidas has started complaining about the striped cloths offered by Forever 21. Also, the settlement of 2015 did not lasted long because right 18 months after this, uh, after its execution, Adidas has discovered even more Forever 21 clothes were being sold that violated the rights. Then in March 2017, Adidas America filed a lawsuit in Oregon against Forever 21 and a number of its suppliers for utilizing the registered stripe mark. Then if we look at the other side of the story, so Forever 21 claims that a three-stripe diagonal design positioned parallel with each other against a background of contrasting color is invalid. Forever 21 wanted to assert that this design is decorative and the trademark should be cancelled. So you can move to the next slide, Satyam. And from here, I hand it over to Akshidi.
Yeah, so am I audible?
Yes.
Yes.
So in the conclusion part, currently we have that Adidas and Forever 21 have reached an out-of-court settlement in a recent trademark lawsuit stemming from the firm's long-running feud. And secondly, Adidas does not use stripes merely as a design element. It is a source identifier that Adidas has carefully cultivated through its investment of hundreds of millions of dollars in advertising and promotions, including its sponsorships of athletes, sports teams, musical artists, and fashion designers. So this was it,
So
and we are open for questions.
yeah. So to sir, to sum up everything, that what we wanted to say is that we know that as I've said, what you have taught in class, that trademark can sometimes be uh, more valuable than combined any other intellectual property. So that's why we see that Adidas has fought with everyone to protect it. And yes, that's it, sir.
Okay. There are two observations. One is, okay, do you have a word file of the term paper?
Yes, sir, we have sent it to you.
Acha. Okay, Ishmael. Second thing is a very small font, say like references. I mean, you can utilize more space. At
Sir,
the top,
yeah.
top and bottom, it is so much of left out space at the cost of visibility and readability.
Sir, basically, if I can present the screen, then laptop hangs. That's a problem. Yes, of course, there's a space, sir. It's just that there are many business articles. There are many news articles that we are reading, but you know that most of the articles for one particular case, there are many articles that comes out. So we are taking out the articles from which we are getting some unique information. So we
That
are
is
limited.
fine.
Of course, we could have filled it with many lines, but most of the articles were containing same things.
चलो ठीक है.
Thank you, sir.
Good.
I don't know how to stop, sir. Just one second.
Stop sharing तो बंद हो जाएगा.
Yes, sir. It's laptop problem. Just one second. Yeah.
So can Glufo start with the presentation?
Yes.
I'll just share my screen. Is my screen visible?
Yes.
Yes. Okay, so good afternoon, everyone. Hope you're doing well. And we are Group 4, consisting of Lakshya, Nihal, Himanshu, and myself, Sohani. And we will be presenting our term paper 1 on IP infringement cases. We have chosen the design infringement case Crocs Incorporated USA versus Liberty Shoes Limited India, and the judgment of which was announced in 2018. So the topics we will be covering today broadly include a brief overview of design infringement. We'll be touching base on some well-known design infringement cases, and then we will also cover the Crocs Incorporated USA versus Liberty Shoes Limited design infringement case in detail. Next slide. Yeah. So design infringement basically means that if an organization has created an original design for any product, they can protect it by getting it registered under the Design Act of 2000, which protects the visual design of objects that are not purely utilitarian. So utilitarian means purely for usage. Let's say maybe anything that is edible or let's say ghee, salt, anything like that. So this also helps them get monopoly rights over their design. No other company or organization can use this design for their profits and causing loss to the proprietor. So design infringement is the infringement of a registered design in terms of the shape, configuration, pattern, ornamentation, etc. by any third-party organization. Some well-known design infringement cases are the BlackBerry versus Typo case filed in 2014 by BlackBerry against Typo Products LLC for infringement of their famous QWERTY keyboard. So Typo was accused of selling a fitted keyboard for the iPhone, allegedly infringed from the keyboard design of BlackBerry phones. So the California Northern District Court granted a preliminary injunction in favor of BlackBerry's registered design. And finally, a settlement was reached in which Typo Products agreed to permanently discontinue selling of their keyboard in question worldwide. And then there was the Apple versus Samsung case for the infringement of Apple's iPhone design by Samsung, which was already covered by another group on Saturday. And then the Carlsberg Breweries versus Soam Distilleries and Breweries Limited case in 2017. So the suit in question was filed, was complaining of infringement of a registered design of the bottle as well as passing off of the plaintiff's trade dress in respect of the bottle and the overall get-up of their Carlsberg logo. So this one was a very interesting case as it was a composite lawsuit filed by the plaintiff against the defendant Soam Distilleries, and it was ruled by the Delhi High Court that two causes of action, which is design infringement as well as passing off, can be joined in one lawsuit. Now, Lakshya will be briefly explaining the background of the case.
Yeah, thanks, Sohani. So, for the purpose of a term paper, we chose the very popular design infringement case, which is Sox Incorporated USA versus the Liberty Shoes Limited. So, over the next 2-3 slides, I'll be taking you over to the elaborated details of the case. How did the case escalate? What points were put forth by both the plaintiffs as well as the defendants in the courts, and what was the final verdict? So I'll be starting off with a brief overview of the plaintiff first, which is the Crocs Incorporated. So Crocs Incorporated is a US-based footwear venture which started in 2004 after they purchased a budding company called Foam Creations. Since 2004, Crocs has been a big name in the industry. They are one of the leading footwear ventures in the world. Even in terms of revenue, they are leading at the top of the charts, having accounted a net revenue of $1.2 billion as of third quarter of 2019. While talking about Crocs, since 2004, soon after purchasing the Foam Creation Company, Crocs has incorporated and bought exclusive rights of the material that is being made to form their signature style of shoes, which they like to call foam clogs, or which are basically a type of breathable or a perforated shoe. So that particular material is a type of a foam resin, which is named as Croslite. This is also claimed to have a lot of medical benefits by various biologists. Adding to those rights, Crocs has also registered various patents and designs across the years. One of the patents is the very famous the breathable work shoes and the method of manufacturing those. And while they registered 3 designs as well, one of which is the design number 197685, which will come up later in the case. Owing to these designs were basically included the ornamental aspects of their product. Now, before starting off with this particular case, I'd like to mention that Crocs Incorporated has been, we have witnessed various occurrences of Crocs lodging lawsuits over other competitors, both in the USA as well as India. Some of those examples were Aqualite, the USA Dogs, and even Airwalk. So now I'll be starting off with the detail of the case. So Crocs Incorporated USA filed a design infringement case in 2016 against the Indian shoe manufacturers Liberty Shoes Limited. So the basic design infringement case was alleging that they had infringed their design number 197685, which I had mentioned earlier, as they had registered this design and it was supposedly valid up to 28th of May in 2019. So the main contravention of the violation was with respect to the particular visual design of their perforated as well as non-perforated shoe designs. So initially the case was filed in various lower courts across different parts of the country, and that too surprisingly against different manufacturers as well. Some of them which included Bata India, Corky, ORS Footwear as well as Relaxo Footwear. While some of the cases were contested by both the parties in court, others were declared as ex parte decisions, which did not require the participation of these parties in the court. Ultimately, the case escalated and was finally transferred to the Delhi High Court for adjudication. Soon after the case was transferred to Delhi High Court, the court came up with two main issues that the infringement case possessed. So the first issue was whether the plaintiff's design, so in this case the plaintiff's Crocs, so whether the plaintiff's design was in the public domain prior to the registration or not. And the second prime issue that was posed was whether the plaintiff's design was new and original or not. For this particular purpose, uh, the plaintiffs claimed Section 22 of the Designs Act 2000, which stated the piracy of product, while the defendants claimed Section 19 of the Designs Act 2000, which claimed cancellation of registration of the product. Now we'll be moving on to the key similarities and differences of the product, which would be presented by Himanshu.
Yeah, thank you, Lakshay. So let's talk about what the similarities between the products were and what their consequences were. So here you can see what is the design submitted by the plaintiff on 28th May 2004. And the plaintiffs claimed that the defendants' products and their offerings were more or less similar to their design. So on the right side here, you can see some of the products that were offered by the defendants in this similar footwear category. And apart from a few color variations and variations in design pertaining to the perforations or holes over the footwear surface, you can see that the resemblance is quite uncanny here. So what the plaintiff did here was that they invoked the Section 22 of the Designs Act, which protects them against any piracy or imitation of their designs. The objective that the plaintiff had in mind was to maintain a monopoly in the market as to their particular footwear segment and stop the defendants from manufacturing and selling their products so that it can maximize its profits, at least up to the validity date of their designs, which was 28th May 2019. So, yeah, they wanted to use the court of law to do this. Moving on to the other side, the defendants claim that the plaintiff's designs were not original, and moreover, they were available in the public domain even before the registration date of the plaintiff's design. So on the left side here, we can see the website of a company called Holy Souls, who were selling the products which were very similar to the plaintiff's design back in December 2002. This is a screenshot of the website dated 17th February 2003, which is more than a year earlier than the registration of the design by the plaintiffs. Moreover, before the plaintiffs submitted their design to the authorities, their designs were available on their website as well. So it can be said that these designs were available on the public domain and they were not new or original, using which the defendants invoked the Section 19 of the Designs Act, which stated that these designs are liable to be cancelled since they're not original and are available in the public domain before the registration date. Yes, we can move on, Laksha.
Coming to the conclusion, so the evidence put forth by the defendants were acknowledged by the court and were favored as well because Croc's design was already available in public domain, as Himanshu mentioned, from year 2002 on their own website as well as by the Holy Shoes website as well. So another reason was that as similar designs were already existing in public domain way before Croc registered for design, the Croc was unable to claim the exclusivity for the same, and hence their registered design was cancelled in accordance to the Design Act. So it was adjudged that the design under question by Crocs was neither novel nor original to be granted protection under the Design Act. And in 2018, the court dismissed the injunction applied application filed by Crocs in suits and awarded compensation of rupees 2 lakhs to, in addition to the legal cost incurred by each defendant, including liberty that was to be payable by Crocs. This landmark judgment was passed by Honorable late Justice Valmiki Mehta of Delhi High Court in 2018. Plaintiffs lost the case in which they had claimed Section 22 piracy against defendants' liberty, who had claimed Section 19, that is cancellation of registration against plaintiffs under the Design Act of 2000. So the key takeaways from this case are that one should thoroughly analyze the scope of design patent protection, and Crocs mainly lost this case because the design of the shoes was already in the market way before Crocs registered for design patent, and therefore one should always take into account such things before filing a design infringement case. And thirdly, the design should also have a novelty or originality to be granted protection under the Design Act, which Crocs clearly lacked here. Next slide. Yeah, so these were some of the references we refer to while making this whole presentation.
Okay, good. Thank you.
Thank you.
But see, it is a carelessness on the part of the Crocs. Crocs managers are not so competent. They spotted this thing much later when the defendants showed them कि देखो ये पहले से market में है.
Correct. And they also publish it on their own website without registering their designs.
Novelty is the most important thing at the time of registration.
Yes.
After filing the application, then you can put it on the website, but not before filing the application. Okay, thank you. Good.
Thank you.
Thank you, sir.
Thank you, sir.
Yeah, hello. Am I perfectly audible?
Yes, you are audible.
Yeah, my teammate is presenting in a bit. Just in a minute.
Oh, okay.
I think there is some connectivity issue. Sorry for that.
Is my presentation visible?
Yes.
Yeah, you can be a bit loud. Fine.
इस कौन का स्पेलिंग तो एक ही है, दोनों में कुछ फर्क है क्या?
No, sir. They are same.
तो इसमें वर्सेस क्या टू ऑर्गेनाइजेशंस?
Yes, sir. Both are different.
अच्छा, ISKCON is the temple वाला and है ना?
Yeah.
Versus that ISKCON apparel. Okay.
Yes, sir.
Please switch on your cameras.
कैमरा चारों लोग ऑन करो अपना.
Good afternoon, everyone. We are Group 5, and our topic is ISKCON versus ISKCON Apparels. This case was filed by the religious company ISKCON against ISKCON Apparels online clothing company in March 2020. So, according to Section 2 of Trademark Law, the Indian legal sphere, the owner has a legal right to protect himself against infringement. And in February 2022, in an online search, the religious company found that a company was using an online clothes selling company was using their name and selling products. So they filed a case against them. They first sent them notice, but no one responded, so they filed a case. So I'll move to next slide. So in introduction, we have mentioned the intellectual property rights and laws that are used in India. They were changed several times in 1911, in 1888 first, then in 1911, then in 1907. And after independence came the laws which are existing in current time. Which were finally curated by Justice Rajagopal Ayyanar and Baksh Tekchand. So our case is based on copywriting trademarks under intellectual property laws of India. Some of whose agreements are borrowed by WTO TRIPS agreement. So the case was filed by a plaintiff against the defendant, and the defendant didn't responded much. So the first case went very fast, and the judgment was based on 4 instructions that were provided by the court. So I'll hand over to Anand to explain these 4 instructions.
Thanks, Priyanka. Good afternoon, everyone. So I'll take the case forward, and I'll closely explain what the judgment was, and we'll try to analyze the judgment very closely. So in June 2020, the Bombay High Court decided that ISKCON, that is International Society for Krishna Consciousness, is a registered and a well-known trademark, and they decided to give them the highest degree of protection. So why is that so? Because it's evident that ISKCON is a new term, and it was coined by the temple authority themselves, and nobody before them has created or used the term ISKCON. So so the court decided to distinguish the products and services so that no one can misuse them in the name of religion. So we'll now go through step by step. So we have 4 commandments of the court, that is Bombay High Court. The first one is, can you move to the next slide? Yeah, thanks. Plaintiff's trademark ISKCON has wide acceptability. I'll try to explain this via another small case that was between Texmo Industries versus Taxmo Aqua Engineering Private Limited. So you can see the sounds of Texmo and Taxmo. They were also like homophones. So in that case, the court decided that the final judgment was that if a mark satisfies the requirements and tests of a well-known mark, then it is entitled to be categorized as such in terms of Section 2.1.ZG of the Trademarks Act 1999. So what is this Section 2.1.ZG? So according to this section, a well-known trademark is the one which has become like most significant to the public in terms of particular goods and services, and use of that trademark for any other goods or services may be linked as a direct connection between the people who first used that and the ones who later adopted it. And it's quite clear from the case that ISKCON was the term coined by it was a newly coined term, and further other companies, in our case the ISKCON Apparel Private Limited, they've used and also publicized the products in the name of ISKCON, and the people who used to believe in religion, they might get duped for money. The second commandment was the court claimed that the popularity of the trademark is worldwide. So let me present a view. Currently in the world, approx 1.3 or 1.4 billion population are Hindus, and that approximately estimates to 15 to 16% of the total world's population. So, and wherever the people belonging to this religion resides, ISKCON quite popular and well known among the community. And we can also see from the example that it's evident from the side that this ISKCON has several branches of, we can say, the temples and charities or NGOs are located in North America, South America, Malaysia, Philippines, Indonesia, and yeah, of course, India and neighboring countries. So moving on, the third commandment was that the trademark is in use since the beginning. So let me tell you the fact that the first ISKCON temple was constructed back in 1971. That is roughly like a half century back. And currently in India, ISKCON has over 600 to 700 temples worldwide, obviously including India and worldwide, making it questionable for the defendant to have used the name and fine ignorance over it. So the court said that according to Section 11.7 of the Trademarks Act 1999, a trademark can be considered as a well-known trademark based on the extent and duration of its use, as well as if it has been used for publication and advertisement since the beginning. And it's quite clear that ISKCON has been publicizing their products and related activities from the like this case is was filed in 2020. So it has been using since the products of 40 to 50 years back. Moving on, the fourth commandment was the plaintiff has already taken several actions in the past, and this is quite this is quite common in India. As you can see, dharm ke naam pe dhanda. So you can see ISKCON Apparel Private Limited, several small companies. Uh, I can refer to the previous case of Satyam, like the first group presented. They had also like Adidas versus Forever 21, and we saw that several small disputes. The disputes were between Adidas and smaller companies. Similarly, here also there were disputes between some smaller companies and ISKCON brands, the original ISKCON temples and organizations. Moving on. So after the court ruled the judgment, there was a problem with this ISKCON, and what was the problem that just a minute. Yeah, sorry. I think my laptop has hung. Yeah, sorry for the interruption. Uh, so an interim injunction granted against the defendant. So what is an interim injunction? So it's basically a sort of temporary order which is given to the plaintiff so that they don't involve in any kind of loss due to the case. Suppose the case goes on for 2 years or 3 years, and in our Indian law, it's also like one is guilty until proven innocent. Yeah. So the court covers every scenario, every aspect that no one suffers the loss. And to solve this, we have in the section 108 of the Patent Act 1970, we have two kinds of remedies for this. The first one is they grant an injunction against the patent infringer, and the second is they appropriate damages that a patentee has suffered from the infringement of his patent. But the problem in both of these remedies are that they are granted after the actual determination of infringement. But as I mentioned, suppose the case goes on for 2 years or 3 years, then like SCON has suffered, then who will cover that loss? So the infringer can file for an interim injunction wherein the court decides to cover the loss, or the defendant cannot use or publicize the products until that time. So yeah, that's from my side. I think Sahil can take over.
Hello everyone. Thanks, Anand. And now we'll look at some of the previous cases which might be similar to our case study. So first case is of Ashirwad Atta and the Ashirwad traders. The plaintiff here is Ashirwad, the Atta company, which obviously from the starting it was producing Atta packages in many countries, and it is popular in countries like India, Australia, Singapore, Canada. And they filed a case against the Ashirwad trade dress, which just was taking their name and popularity for selling its dresses. So this Madras High Court gave a judgment in favor of the plaintiffs Ashirwad Atta, as it already has a well-known name, well-known brand. So the judgment was in the favor of Ashirwad Atta. The next case is of Texmo Industries versus Texmo Aqua Engineering, which Anand already told about. In this case also,
You have 2 minutes left.
The Texmo Industries, the judgment was in the favor of Texmo Industries. So let's now look at the few laws which were used in the judgment. Now this is the NICE Classification Agreement of 1957, which provides us several classes used for classifying goods and services for the purpose of trademark registration. So the classes are as follows. Class 16, this includes stationery and office requisites, furnitures, adhesives. Class 23, this includes nature and synthetic yarns, textile usages, etc. Class 24, this uses fabrics and fabric covers for residential usage. Class 25, this includes human apparel, footwear, headwear, and most parts of clothing. Class 35 includes services rendered by advertising establishment. These are basically for commercial enterprises and services rendered by advertising establishments primarily undertaking communications to the public. Class 42, this consists of primarily services rendered by individuals in connection with theoretical and practical parts of complicated fields of activity such as scientific or laboratory services. Now let's see some of the articles, which first article is section 2, article 1 ZG. This also Anand explained. This is the well-known mark, Trademark Act, which means a mark which has become so substantial segment of the public, which uses such goods and services that has these goods and services of a particular brand has made a connection with the people, so that the products which people want to buy first come names is of that company or firm. Let's see the other two sections. The section 11, article 6. In this registrar shall determine whether a trademark is a well-known trademark or not. So factors for that are the knowledge or recognition of the trademark, the duration, extent, geographical area of the promotion, the geographical area of any use of the trademark, the record of successful enforcement of the rights in that trademark. The next article, section 11, article 7. In this article, the registrar shall, while determining whether a trademark is known or recognized in a relevant section of the public, for the purposes of like mentioned in the section 11 article 6. This takes into account several factors, which are the number of actual potential customers, the number of persons involved, and the business circles dealing with the goods or services. Also the section 135 of the Trademarks Act, which this act allows may grant in any suit of infringement or passing of referred as in section 134. This allows any like damage to the properties and in the favor of plaintiff together with and without any order for the delivery of the infringement labels. Now let's look upon the conclusion part. So I guess Minal will take over. Minal, you're muted.
Share. So after the first case itself, the cloth company again tried to use the name of the ISKCON trademark. So what they did was they were using the name formerly known as ISKCON Apparel PET. So the ISKCON has to again file the case against the defender. So the facts about this second case was that the ISKCON alleged the clothing maker ISKCON Apparel PVT that it has violated its registered trademarks to sell the clothing or online. So the problem with this was that since the clothing company was using the name formerly known as ISKCON, so due to that there were many plaintiffs who were misleaded to it, and they thought that the ISKCON apparels were previously associated to ISKCON, and since ISKCON was ISKCON was very widely known and globally famous for its devotion for Lord Krishna, and it also sends their advertising material such as religious books, literature, etc. So this case was accepted by the Bombay High Court. And now what issues that we might think that would have been with this, that why is there breach if the defendant's business name has already been changed? So as I discussed in the previous slide, just because they use the phrase formerly known as ISKCON Apparel PVT, it misleaded customers into believing that they were previously linked to the plaintiff. So now ISKCON claimed that they were a well-known trademark. So how did this claiming occur? So there is a criteria which is established to determine that whether a certain trademark is well known or not. It is clear that ISKCON, which was founded in 1966, is widely recognized as a religious organization, and it also sells its own products under the same brand name. So it perfectly meets the status of a well-known trademarks. Okay, so now I like to conclude our presentation, and I like to tell how things happen. So like to generate profits, the defendant use the name of a well-known trademark. The religious organization is the only one who has authority to promote his philosophy through its products. Due to defendants' uses of it, plaintiffs' followers were cheated, and they were made to believe that the items belong to them. They can be conned this way. So as a result, it was determined that the parameters required to be considered for a well-known trademark under section 11.6 and 11.7 of the Trademarks Act 1999 are met in the case. Or like we also discussed previously, this was the same case with the ITC Limited where versus Rani Sati Food, where they in the same manner they declared Ashirwad as the well-known trademark just because it was very much popular in countries including Australia, Singapore, Canada, and United States of America, and also had a large advertisement. So when deciding whether a trademark has been violated or not, courts consider several issues. In this case too, the decision was correct and the corporation was forced again to change its name. The court also granted the plaintiff's demand for an interim injunction against the defendant. Yeah, so thank you.
Say just 1 minute कि it was a almost a second offense. एक बार उसको बंद कर दिया, फिर दोबारा second time again he started, तो अब उसको कुछ ज़्यादा punishment नहीं किया कोर्ट ने. It is a serial offender.
Yes, actually, yeah, it's a very serious kind of offense because they used that formerly known as ISKCON, but we couldn't find any source which claimed that they were fined or penalized for that.
Okay.
Like at least it's not available on the internet.
ये काफी सारे जो है, हाउ डिड यू गेट इट रेडीमेड थिंग्स, ऑल दिस सेक्शन वगैरह सारा ही कैसे बनाया?
No, sir.
काफी जगह से
Like
मटेरियल लिया?
Yes,
yes,
sir.
sir.
We
No,
find laws from various sources like the
Exact laws.
WIPO's site, the NICE classification site, and like other site like Indian Qanun and various other sites.
Because see, I don't expect anybody to do anything original. It is all the thing, but you have done, seems to have done a good work in terms of, time searching and all that. Good, thank you.
thank you.
sir.
Sir, next is our group 10, group 6. So I'm Himanshu, and can I present my screen?
Yes.
Yes, sure.
So I'm just sharing my screen. Please let me know if I'm not visible to you.
And group 8.
Share
अच्छा,
cut.
group 6.
Screen windows.
कौन सा group है?
Here it is.
Group number 6.
So is my screen visible to all of you? Is my screen visible to all of you? Sir?
Yes.
So I will start my presentation. So good afternoon to all of you. I'm Himanshu, and this is group 6. So our group 6 is
Every
Himanshu.
group member can switch off their camera.
Switch on my camera, of course. Yeah. So should I start, sir?
Yes.
And where is the fourth
So,
member?
he should be just. I believe all the members are. Just a second.
Okay.
एक बार चारों अपनी शक्ल दिखा दो.
Yes, sir. So should I start?
पहले एक बार वीडियो ऑन करके अपनी शक्ल
Yes.
दिखा दो चारों लोग.
So we all are here. So should I present?
चलो चालू करो.
Okay. Good afternoon to all of you. This is group 6, and this is the presentation for MSL 802 term paper 1 group 6, and the group members are Himanshu Goel, which is me, Khushi Obroy, Harshit Gupta, and G. Pranil Jefferson. And today we will present you the case Waymo versus Uber. Let's start. So firstly, we will discuss about the parties involved. So the first party is Waymo, which is the plaintiff in this case. And those of who don't know what a plaintiff is an organization or an individual that brings the case in front of the court seeking for a legal remedy. So Waymo was a self-driving car project started by Google employees in 2009, and during the restructuring events of 2016, it was officially outspun out of Google and formed as a separate private organization under the Google's parent company, which is Alphabet. And in 2017, it became the first company to put a fully self-driving car on US roads without a safety driver. And Waymo is the one which initiated the lawsuit in this case under the section 18, under the title 18, section 1832 of the US code, that is the preventing the theft of trade secrets. And as per the title 35 code 271 of the US code, which prevents patent infringement. And the other party involved is Uber, which is a worldwide recognized taxi hailing company started in 2009. And this organization is the one which is accused. So moving to the next slide, let's take a look at the allegations involved in this case. So the allegations in this case are similar to the plot of an Hollywood movie. So in 2009, the former Google employee Anthony Lewandowski was one of the heads of the self-driving projects of the Google. And few years later down the road, he decided that he will not continue to work for Google for the upcoming years. So he secretly uh, stole the trade secrets related to LiDAR technology. And in the simplest way in which I can put what LiDAR technology is, LiDAR technology allows the cars to see what is in front of them, and basically making it the core of self-driving cars, the core technology of self-driving cars. Along with it, Lewandowski allegedly downloaded 14,000 secret documents before leaving Google. And in 2016, he had a meet with the Uber executives, and the Uber actually wanted him to work for his company, but Lewandowski wanted to start his own company, so they founded a way in between. So Anthony started on self-driving trucks company called Auto, and 8 months after that, it was acquired by Uber, for $680 million. Now, uh, now Waymo allegedly claims that Uber, with the help of Anthony, used all the secrets, all the trade secrets, and the lidar technology that was stolen by him, and used it to develop its own technology within a short span of 9 months, because it didn't want to get beat in the race of the self-driving cars, and that is all the allegation which are involved in this case. Now, moving to the next slide, I will hand over to my fellow group members.
Can you please move to the next slide? It's not visible.
Is it visible now?
Not moving.
Is it visible now?
It's not moving. Yeah, it's visible now.
Yeah.
So, trade secrets stolen. What exactly are trade secrets? Trade secrets are the secret devices or products used by a company to manufacture its products. So, as Himanshu already mentioned, Lewandowski downloaded more than 14,000 files related to Google's self-driving car technology, and it was the plaintiff claimed that these technologies were used by Uber after they hired Lewandowski, and unlike today, at that time, LiDAR technology was very new, because of which it was hard to decipher which out of the biggest two giants, Waymo and Uber, was the creator, and which who stole. And also, since Waymo was the one who filed the case, the whole pressure was on Waymo to prove that Uber had acquired Otto and hired Lewandowski with the sole purpose of using these trade secrets. Their claim was also supported by the fact that Uber tried to safeguard Lewandowski from the claims that were part of the acquisition. Next slide, please.
Just a second. Is the next slide visible? Just a second. Is the next slide visible?
No.
Now?
No, I think there's some lag. Yeah, it's visible now. Okay, so the case was held in the Federal Court of San Francisco. Waymo was trying to prove the over-competitive attitude of Uber. It also presented some memos that suggested that Travis Kalanick, the Uber's former CEO, would do whatever he could to take advantage over its opponents by also getting hands, even if that meant getting hands on all of their data. Waymo tried to make an analogy between Uber and someone who uses cheat codes to win a video game. Till date, it is believed that the sole purpose of Waymo filing this case was because they saw Uber as their biggest threat in the race for creating self-driving cars. So on the other hand, Uber was solely trying to prove that they hired Lewandowski and acquired Otto with the sole purpose of acquiring talent, and not with the motives that were mentioned in the case. The case went so personal that the CEO of Waymo even claimed that he used to be friends with Lewandowski, but after he quit, they became enemies. And because of that, Lewandowski was trying to betray the company by sharing the secrets with its biggest competitor. Next slide, Harshit.
Moving to the next slide.
What needed to be done? To avoid losing the case, Uber had to at least prove that it followed all legal processes when it hired Lewandowski and didn't hire him because he had access to Waymo's trade secrets. They had to make the court believe that although Lewandowski might have had the documents, but they never reached the Uber servers and were not used by them, and that their designs were different. They tried to shift the responsibility of all the wrongdoings on Lewandowski and the startup he created named Otto. Can we move to the next slide?
Moving to the next slide.
Drama in the end. There was a dramatic last-hour twist before the trial when a letter emerged from a former Uber employee suggesting that many of the things that Waymo alleged were in fact true. It ended in a peace treaty. Uber gave Google's sister company a 0.34% stake in its business and pledged not to use any of Waymo's software or hardware in its vehicles. The reason for Uber settling could have been the fact that Lewandowski refused to support Uber in its position that it had utilized no trade secret of Waymo and that left Uber vulnerable. Uber could have come out as a party which was unknowingly using some other party's trade secrets, and the court's judgment could have been based on that. Next slide, and Pranil will take over from here.
Yeah, sir. So, am I audible? I guess I am.
Yes.
Now we have to talk about results and consequences for the parties. The case did last for 1 week and it was settled in 2018 February. So this fight between both the big companies, Uber and Waymo, finally ended in a peaceful way, with the verdict finally coming in much favor of Uber's interest. The compensations were to be paid to Waymo by Uber, as mentioned, as a 0.34% stake in its business, and Uber, which has already sold $350 million of its shares, will get two-thirds of it back because of this settlement, and hence we call it much favor in terms of Uber. This mutual agreement was like actually Waymo didn't want it to be too harsh on Uber, as Uber's demise would have not meant anything to them as well. Lewandowski, who was the main culprit in all this, he was charged to prison in 18 months. And after all this happened, Uber CEO has officially apologized and he has regretted that his company would have not wanted to all this happening. Can we move on to the next slide, please?
Yeah, so moving to the next slide.
Okay, relevance of this case in today's era, like this actually gives, we have to think about this in three perspectives. One in terms of technology, the second one being company, and the last one as an individual working in firm. So at the time when Lewandowski actually worked on LiDAR, it was the fast growing technology, and AI was not that significant in that times. So that has prompted Uber to take this LiDAR, and Uber thought that stealing this would have been worthy, but unfortunately, after so many years, this technology has grown so faster that LiDAR has no more that great significance today. And so this simply means that no matter how innovative the technology is, stealing it would still cost a lot when it comes to companies and individuals. And talking about the company's perspective, in this case, Uber was on the verge of paying $1 billion penalty or completely shutting down the business of manufacturing self-driving cars. So going for a simple mistake can lead companies to pay a lot, like Uber did in this case. But luckily, in this case, Uber was saved by this settlement. And talking about Lewandowski as an individual, like he was very innovative. Like he was the one who played an phenomenal role in making a LiDAR, but unfortunately, his greediness, which has led him to make his own startup and things like stealing of 14,000 files, has completely put him now under a bad situation, and he has to go to prison for 18 months. Now, Himanshu will summarize the rest of it.
Yeah. So these are the sources. Now, so concluding the presentation, if we look at the case, it is a classic case of patent infringement and stealing of theft of trade secrets, in which a former employee decides that he don't want to work for the company anymore. He steal all the secrets. He then joins the rival sides, and when the things get heated up, and in the court, he eventually ends up betraying the rival side as well. So this is how we can actually summarize the case between Waymo and Uber. And the amusing fact about this case was that even though it was the most public case that was there in the public domain for the last half a decade, but it eventually got settled within less than a week, that is 5 days. And the one important aspect that one needs to understand in this case was it was not the monetary compensation that it actually hurted Uber more, but also the fact that along with the settlement, Uber had to actually apologize and accept the fact that they did in fact stole the technology from Waymo to build their own technology. That was because that was also the key aspect of the case. That was for Waymo to prove uh, that Uber was saying that what if Lewandowski stole the technology? You have to prove that whether Uber used it, and eventually when it got proved, so Uber had to admit it, and there was a great loss of public image for Uber as well. So this is how we can summarize the case at last. So thank you. With this, we formally end our presentation.
ये 1 minute. ये ओला के साथ तो नहीं हुआ ना, भवेश के साथ?
नहीं sir, this was only with
नहीं
Uber.
नहीं, उबर के साथ हुआ, बट वो सेम टेक्नोलॉजी है दोनों का लगभग.
Sir, I think the thing that one needs to understand was कि Uber actually wanted to not being left behind in the race of self-driving car. Building its own technology was not the issue, but the important factor was the time factor. That's why they were resorted to stealing the.
What is your definition of self-driving car?
So self-driving car means there is no driver in the car.
Okay.
Yes, sir. With that, we formally end the presentation, sir.
Okay. Thank you. Which is the next one?
Yes, sir. Group number 8, we are here.
Okay.
Just a second, we are presenting.
Payless.
Yeah. Shikhar, are you there?
Hello.
Yeah, you are audible.
Can you see my screen?
Yes. Just make it full screen.
Hello.
Yeah, your screen is visible.
Yeah, so can I start?
Yes.
Yeah, so we are group number in 8, and we are here to discuss about the topic Adidas versus Payless. This has been one of the most important and well-known cases in the history of infringement claims for the trademark, not just because of the high damages that it imposed of $305 million, but also the drastic impact that it created on the trademark infringement cases. So to get a brief idea about the background, let us discuss the timeline of how things escalated. In the year 1994, Adidas was reputed for its three stripes, and it was selling that. And in the year, and it signed an agreement with all the other companies who were also selling the three stripes, so that they can stop their selling and just Adidas can have a monopoly in terms of the shoes that have three stripes. Payless was also one of the companies that signed the agreement with the Adidas. In the year 2001, Payless was selling two stripes and four stripe shoes, but that was affecting the business of Adidas, and that is why they filed a class action law case again in the district court. But that was dismissed because they were actually not breaking the law, because they were actually allowed to make two stripes and four stripes. In the year 2006, finally Adidas sued Payless again, but this time for the trademark infringement case. And we're going to discuss in detail what happened in this case in this presentation. Priyansh?
Next slide, please.
This is Adidas background.
So we have to first take into consideration the background of the respective companies. Adidas being a German multinational company founded and headquartered in Herzogenaurach, it's as we now know it, it's the largest sports manufacturer all across the Europe, and it's the second largest in the world. So Adidas basically revolutionized the production of heavy metal spikes, and then due to change in laws, due to change in injuries, etc., it later switched its business model to canvas and heavy rubber. So Adidas as of 2018 has been one of the most successful companies as we know all across the world. Similarly, Payless, next slide, please. So Payless was founded in 1956. Basically, the whole business model of Payless, in retrospect, was bringing the most authentic products at a much lower price range. So this was the most revolutionary companies according to me, but it just made a ton of bad decisions which made it fail a lot in retrospect. So Adidas was known as the three stripe company. I'll just pass on to my partner.
Please switch on your cameras, all the four group members.
Hello, hello. I'm audible.
Yes, you are audible.
Oh, I'm sorry for the network lag. So, just can you move to the previous slide, please? Yeah, thank you. Next slide, yes. So sorry for the network lag. So basically, Adidas sued Payless in year 2001, and the claims which Adidas made was the intent to infringe, and it alleged that the infringement has tainted their image, their registered trademark, which is the three stripes, and it is basically pointed towards the delusion of the image. And he said that Payless has been breaking the 1994 agreement. The He has been breaking the agreement since 1994, the agreement which was made in 1991, which was told by Shaker as well. And I think the previous group also mentioned this thing, like the Adidas versus Forever 21, where Adidas made an agreement with the smaller companies. So it made a similar one here also. And he also brought several issues to the Ninth Circuit, which is the District Court of the US. Yeah, next slide, please. So Adidas claimed what with the issues which he filed, the claims for relief were the Federal Trademark Infringement Act of three stripe mark, which is basically the 15 USC 1114, and he also filed under the Federal Unfair Competition, which violates the 15 USC 1125A law, which is basically the three stripe mark and three stripe mark and the superstar trade dress, which is basically a lotus type logo of Adidas, and it also claimed under the straight trademark delusion and injury to business reputation, which violates basically the ORS 647.107 of the US law, US code, and various other straight laws, which basically violates because they have been using the three stripe mark and the superstar traders. And they also filed under some common law infringement acts like unfair competition, deceptive trademark practices, delusional damages, and everything. And next slide, please. On the other hand, in the defense, Pele said that there was no willful intent. The word willful here is important because Pele had said that they might have infringed, but there was no willful infringement from their end. And they also said that Adidas trademark has no major popularity after the registration. And I think on this point, the previous group has also mentioned. I think I heard regarding the ISKCON where the court said, like, if uh, if a trademark is very much well known to the world, a significant population is being using that trademark and everything. So Payless said the same thing, that Adidas trademark has no major population after the registration, and they also claim that the joint marks, basically on the three stripes, there are joint marks which of Adidas are straight edged rather than the serrated ones.
You are not audible. You have switched off your mic. Speaker, unmute करो. Please unmute. Priyansh, unmute.
Sir, we are waiting for another member, I think.
अच्छा. तो जो अभी मेंबर्स हैं वो प्रेजेंट करें इसको क्विकली. ठीक है. The whole class can't wait for one person in midway between the presentation.
His internet collapsed, I think.
He was here earlier.
Shikhar, can you continue?
Hello. Is there okay? So before the case, these were the motions that were put up. So there were some motions from the Ejida side that was for the partial summary judgment, and this was based on all the claims that was shown in the previous slide by Utkarsh. In opposition to these claims, these motion, Payless had filed for all the motions that are written below. First was to strike the plaintiff's demands for a jury trial, so they even didn't want that a trial should be taken place. Another one was for the summary judgment of the IJA's claim for willfulness, where they wanted to show that they don't have a will in terms of they did in good faith what they did. Also, they had a summary judgment dismissing the Adidas federal and state dilution claim that the trademark dilution was not present. Also, the trademark and trade dress infringement motion to dismiss that as well. Also, Payless motion for the summary judgment on the defense of the lashes. And then there was final report by the Dr. Gerald Ford that actually was a survey that was done, which showed that there was an initial interest of confusion between the customers while looking at the Adidas shoes as well as the Payless shoes. So this was the main report that actually led to Adidas's favor in the court, and that is the main reason why Payless wanted to strike the Rule 26 of this report of Dr. Gerald Ford. Ratul, are you there?
Hello, am I audible?
Yeah, you can start.
So the first thing to discuss here is the intention of PLS in this case. So the court first discussed if PLS's motive to do this infringement was based on an agreement, or did they just do this for revenue purposes? The second point which the court proceeded with was that did this infringement lead to the defamation of Adidas and tainted the image of the original three striped Adidas shoes or not? The next third point, which was discussed in the court, said that the two or four striped shoes created a problem in the initial interest of the customer and basically not in the post sale confusion, as the customer didn't really identify what Payless was selling to them. Uh, yeah, what Payless was selling to them is stolen from Adidas. So, next slide, please. In order to identify the depth of the problem, the court conducted a survey in the market where 232 shoes of Payless were handpicked from the market and reviewed by the officials as well as the customers. So the result of this survey came out to be that the two or four striped Payless shoes had actually resulted in a negative perception of Adidas, as the Payless shoes were of low quality and nowhere near what Adidas was manufacturing. Yeah, so that's all what happened during the court proceedings. Because we will continue from here.
Yeah. Am I audible right now?
Yes.
Oh, I'm so sorry. I don't know what is happening right now. So let's come back to the verdict, leaving that all thing behind. So let's come to the verdict. So the Ninth Circuit of the US, basically the Ninth Judicial Court, it decided on the first point which Adidas made, that the Payless sneakers are very much comparable to Adidas, and it passed on a very historical decision that an infringement claim that should not be evaluated on a very mathematical premise, that is like 3 stripes not equal to 4 stripes or 2 stripes. Rather, at that overall effect of the alleged infringement should be considered, right? Instead, it determined the case on the basis of confusion theory, which Ratul said that they created a survey and everything which entails examination, relatedness of the consulting parties, goods, the nature of similarities that exist, the defendant's intent, any evidence or any genuine confusion, right? He said that there is sufficient direct and circumstantial proof like that that Payless has copied the Adidas brand, and it also ruled out the good faith interpretation that there was no willing purpose to infringe. So basically, it ruled out that they have been done this purposely. There was no good faith interpretation that they didn't have any willing purpose to infringe. Next slide, please. Yeah. So further demonstrated, as mentioned by Ratul before, like they given them a customer survey that also gave a proof like of the potential confusion that was created between the customers, between the 2 stripes, 3 stripes, and the products were fundamentally similar. So Adidas here, J said that because their quality is very much high above their standards, so it is tarnishing the brand's image. And they also determined that the 3 stripes mark and the superstar trade dress, this flower like symbol, they both are validly registered and are different. So this is undisputed, and this is undisputed for Adidas. And so they awarded Adidas an actual damage of 30.6 millions. They also awarded them a lost profit of 137 million and a punitive damage of 137 million. So overall it passed on a historic decision of giving them $306 million. And later the Palace, they re-sued in the district court. So the district court decided, not the judicial court, the district court decided that the defendant's post-trial motion were not a matter of law, and it accepts that the punitive damages granted by the jury are too high. So despite the defendant actions, it was determined that the punitive damage were excessive. So they lowered the punitive damage to 15 million, and the lost profit also to 19.2 million. And so this was a very historic verdict which was passed. Yeah, next slide, please. So from here, Shikhar will continue.
So let's look at the future outlook and what we learned from this particular case. So in this case, there was a basic argument of whether it was in good faith or bad faith that was conducted by Payless, which had a no definite proof. But this case focused on the dilution of the trademark that was carried out in the court proceedings, and as said in the verdict itself, that if the dilution of any trademark could be proven, that is valid enough to show that the trademark infringement has happened place. So this shows that it's not just direct copying of any product, if of any trademark, but if we have infringed, or if we have tried to copy something which is even diminishing or diluting the effect of any important trademark, then that would be considered as a trademark infringement in the eyes of the law. So there was also this will open up the path for the courts to consider the non-intentional infringement allegation, in which the defendant will assert innocence. So basically in this case, Payless filed for that it was innocent because it had any non-intentional infringement, and that was ruled out because of the dilution of the trademark that was actually proven in the court law. And that is the end. Thank you.
What exactly was the dilution in this thing? दोनों का जूता ही था ना, शूज थे ना दोनों के?
हाँ, शिखर, can you go to the 5th slide? Actually मेरा नेटवर्क चला गया, मैं उसे एक्सप्लेन करना चाहता था. So I will just explain it here. Just move back 2 slides. back. Yeah, so you can see the shoes here. आप एक बार यहाँ पे जूते देखो कि Adidas के लेफ्ट साइड वाले Payless के राइट साइड है, तो कितनी ज्यादा कम मतलब सिमिलैरिटी है यहाँ पर. So इसको लेकर के केस हुआ था. Adidas, you can see that even the sole they have tried to copy the sole, and in the below that bottom left image is basically the superstar.
I am asking dilution.
हाँ, दोनों के जूते ही थे. हाँ, only dilution was only.
Dilution जैसा है कि Mercedes का जो था लोगो, उसका उसने एक अंडरवियर को पहना के बताया था सर्कल के अंदर. तो वो है कि भाई अंडरवियर आप मर्सिडीज का एड, मतलब मर्सिडीज का लोगो को आपने एक कच्चे बनियान के उसमें डाल दिया, तो वो मैं उसका केस था ब्रांड डाइल्यूशन का।
सर एग्जैक्टली, सो इन दिस
ये
केस
दोनों जूते हैं ना, मतलब आप कहेंगे एक 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 आपका है कि जो एक आदमी है जो मैरिज की शेरवानी बेचता है, या कोई है कि जो होता है ना जो मैरिज के टाइम पे साफा लगाते हैं सबके ऊपर कलंगी, उस टाइप की चीज हेड के ऊपर, और जूते का डाइल्यूशन कर दे उसी ब्रांड का, वो डाइल्यूशन होगा। पर इट इज बोथ अ फुटवेयर, तो इसको ब्रांड डाइल्यूशन क्यों मानते हैं इसको?
Sir, so Adidas actually pointed this out in the quote that Payless is not a superior brand as compared to Adidas, and Adidas has a good image of shoes that exceeded the quality of the shoes of the Payless, and that is why they said that having a two stripe or four stripe resembled with a low quality in the eyes of the customers, and that is why putting
Dilution.
this, yeah, that is why it is having the dilution.
Yes.
Okay. Good. Thank you.
Thank you.
Okay. अच्छा, अब 3:30 हो गया है, क्या प्लान है, कुछ करना है? दो रह गए अभी शायद, आई थिंक।
Sir, we can take it today.
रुकेंगे लोग अभी?
Sir, I guess so. Only 2 groups are left, sir, so we can present.
चलो करो जल्दी करो। Sixteen and 11 कौन है अभी पहले?
Sir, 11.
Okay, start.
Shall we start?
Yes.
So, good afternoon, everyone. This is group number 11, and our topic is Ranbaxy Laboratories Limited versus Dua Pharmaceuticals Private Limited. So, Ranbaxy Laboratories is a well-known pharmaceutical company. They manufacture the depressant diazepam in 5 milligram tablets. These tablets were sold by them under the trademark of Calmpose, that is CALMPOSE, and they have had this trademark registered since 1970. So the company made about 40 crores from selling this drug, and from January to August 1987, they have spent around 16 lakhs on promoting the sales of drug under this trade name. This medicine was sold in two-color packaging, silver and brown, and was packaged with polythene film in one side and aluminium foil on the other side. Now Ritu will continue.
Next slide. So, what was the case exactly? So, Dua Pharmaceuticals started manufacturing a medicine similar to Calmpose and marketed it under the name Calmpros. What it just did was inserted a R in an already existing trademark, Calmpose. The two terms Calmpros and Calmpose were visually and phonetically similar, and adding to the confusion, the packaging of the two drugs were also similar. Dua Pharmaceuticals started selling it in the similar packaging, that is in silver and brown color, and with packed with aluminum foil one side and plastic packaging on the other. So, Ranbaxy Laboratories filed a suit against Dua Pharmaceuticals at the Delhi High Court, alleging that Dua Pharmaceuticals has infringed its registered trademark Calmpose, paying for a perpetual injunction and for a decree for rendition of accounts. Next slide, please. So, what was the issue at the hand? So, the trademark Calm Pros used by Dua Pharmaceuticals was an infringement of registered trademark Calm Pros of Ranbaxy Limited or not. Sorry, laboratories or not. Next slide, please. So the rule of law that need to be evaluated in this case was if a trademark is too similar to or identical to an already registered trademark, then it is an infringement of the already existing trademark. Now Shreya will continue.
Isn't this a case of passing off?
Shreya, you are not audible.
So I'll take it. I'll continue from here. Analysis. An interim injunction was issued by the Delhi High Court that restrained Dua Pharmaceuticals from selling the drugs. In the reply, Dua Pharmaceuticals contended that Campros is a prescription drug and is sold by the chemist on prescription only, or when customers specifically ask for it. Thus, there is minimal chance of customers getting deceived. It further contended that the two trademarks, Campos and Campros, are phonetically different. Dua Pharmaceuticals contended the two trademarks are phonetically different with reference to the Stamet Private Limited versus Hens Chemicals. In this case, Entozyme and Entozyme were the two trademarks involved, and the High Court gave the decision that the two trademarks were different. It was contended by the Ranbaxy laboratories that the reputation for the drug case, that is, for the drug, Campos, has been built by it over the years, and Dua Pharmaceuticals deliberately attempted to adopt the trademark through the minor changes to its advantage. Next slide. On 22nd July 1988, the court gave its judgment stating the two words Campos and Campros are visually and even phonetically similar. The defendant just introduced R in the middle of the already registered trademark. Defendant's intention was clearly to cash in on the reputation of Campos drug, which was built by Ranbaxy Laboratories over the years. Certainly, what happened was not a mere accident that the defendant has coined or hit upon the word Campros. It was a deliberate attempt to adopt another person's trademark to one's advantage. According to the court, there was a great likelihood that both the medications would be available at the same store and the Campros would be sold to the customer mislabeled as Campos. Because the packaging, color scheme, and other aspects of the product were identical, the chances of the client becoming confused were higher. The Delhi High Court made the order against Dua Pharmaceuticals from selling Campros final and absolute in light of these consideration and after a thorough examination of the facts of the case. Next slide. Concluding words. In each scenario, the law relating to passing off and nearly identical trademarks is construed differently. The court found that the trade names Entozyme and Entozyme were not phonetically similar in a case concerning the trade names Entozyme and Entozyme. Each case must be resolved after a thorough examination of the facts and concentration of the likelihood of confusion that the average consumer may experience when comparing the original and imitative trademarks. Next slide. Yeah, these are the references. That's all. Thank you.
Thank you. एक फोटो तीनों का नहीं है, one is missing now.
No sir, she was here.
अच्छा, तीनों एक साथ फोटो दिखा दो अपना. अब सुरभि मिसिंग हो गया. हाँ, चलो, okay, thank you. Only group in which all the three are girls.
Thank you, sir.
Can we present now, sir?
Yes.
Group 16. Is my screen?
Yes.
Screen visible, sir?
Yes.
Where are the other two members?
I'm here, sir. And Aman is also present.
And fourth?
Fourth, sir, he's traveling
Okay.
at the moment.
Ask Aman to switch on his camera.
Sir, can we start?
Yes.
Yes. So, good afternoon, everyone. My name is Dharmanshu, and me and my teammates are here to present on the topic Akan Semiconductors versus Huawei. So, basically, Huawei is a very big tech giant. It's number two smartphone manufacturer in the world, and Akan Semiconductor is a US-based startup. So, this is the case of infringement of a design of Akan Semiconductors product. So, basically, the Akan Semiconductor was founded in 2013 by Adam Khan in US. So the main is on a diamond and semiconductor and nanocarbon technology. So what was done that Huawei has made basically for our smartphones, there is Corning Gorilla Glass. It's a very tough glass which protects our phones from dust and fingerprints marks. And when the phone gets accidentally dropped, it protects the screen. So Akhan Semiconductor has made a new version of that glass using diamond technology. So diamond particles were used, which had strengthened the toughness of the glass to another level. So this is the information about the product which was developed by Akhan Semiconductor. And the next in the scenario is Huawei. Huawei is the second biggest smartphone manufacturer in the world, and it's the biggest Chinese tech giant. So basically, what happens in China is that everything is controlled by the Chinese Communist government, and Huawei is said to be very close to the Chinese Communist Party. And Huawei was also founded by a PLA, which is the People's Liberation Army, retired head, Ren Zhengfei. So he was responsible for that. And Huawei is basically in the news because it was banned by the Trump regarding the case which we are going to discuss in our presentation. And the 5G equipments which are made by Huawei is cheapest in the world. Basically, there are only two as Ericsson and Nokia which are making the 5G technologies, and the Huawei offers the best and the cheapest product 5G technologies and equipments in the world. So what was done? This is the image of the glass which was developed by Akhan Semiconductors, and this was meant for the protection of the phones. The phone glass, it was used to be replaced. So a sample was sent to the Huawei. But what happens was that when Huawei sent back the sample, it was all shattered. It was broken into pieces. And then Hakan Semiconductors came to know that Huawei had tried to cheat them by trying to get the materials, the
You are not audible.
So it was basically time. I'm audible, sir.
बीच बीच में बहुत कट जाती है आवाज broken.
Sir, just a minute, sir. I'll change my Am I audible now, sir?
Yes, but you are at two places, I think.
Yes, sir. So this was the glass which was sent to the Huawei, and Huawei had sent it back in a very shattered and broken form. Huawei had tried to steal its way, and this was found out by the Akhan Semiconductors, and this was and a raid was also conducted by FBI with Akhan Semiconductors along Huawei, and after which there was Huawei ban. The US government under Trump had banned all the connections with this tech giant and had barred US companies to trade with the Huawei. So regarding this case, my friends are going to talk about this. This is basically the semiconductors patent which was filed by Akhan Semiconductors in 2017, and the patent was granted in 2020 to Akhan Semiconductors. Basically, this case was happening around 2019. So this patent has been filed. It was named under Akhan Semiconductors, but it was granted at a later stage with the help of FBI, because FBI was going to conduct a secret operation against Huawei, because it was assumed, and it has been proved in several cases, that Huawei is acting as a surveillance for the Chinese Communist government in many countries. They tried to steal the secrets of that countries and sold it to the Chinese government. So my friend Aman is going to take over from here.
Thank you, Dharmanshu. So even, yeah, this is not the slide, Dharmanshu. Wait, please open that Google link.
This one.
No, like slide has been changed. The one you showed, it is that only, but it has been changed. So, or I can just speak from that only. Okay.
Yes, you can continue from here. Actually, sir, the third member is not here, so that's why there's little confusion. So this
Okay,
is us.
I speak this slide. So even before the patent was made, that is before 2017, Huawei had an eye on this technology. So on 2016, an Huawei representative, which is Angel Han, contacted Akhan, who is the owner of Akhan Semiconductors, that he is very interested in this technology and wants to know about this more. And she also said that our company is always looking for this new innovative startups, and we would love to see what this new technology is all about. And she showed urgency in this technology. And when after that investigation was held, that after it was and she was called that, why were you calling and collecting information without any reason? Then she hung up the call and said that I don't recall Khan. So that was very suspicious behavior of her. So next slide, please. Then after a few allegations, finally a deal was made between Akhan and Huawei, and the two companies decided that Akhan will ship them their patent and their two Mirage samples for 60 days, and they will have to return it after seeing it and using it. And also it was decided that Huawei will promise that the sample will return in 60 days, and it will limit it test to that it may perform on the sample, and make sure that there will be no damage caused to the sample. This provision is standard in the industry and is designed to make it hard to reverse engineer any intellectual property. Next slide. But the trouble was caused when Huawei did not return the sample in 60 days. When the sample did not come, Akhan, the CEO of Akhan Industries, called Huawei's manager and emailed her, but there was no response to the emails, and the emails were ignored. After one more month, Han wrote that Huawei has been performing standard test on the sample, and also sent him the photo with a big scratch on the surface. After 4 months of wait, Huawei finally sent the sample, and it showed out August 2. The sample looked similar to what he sent from outside, but when he opened it from inside, thus it rattled. And when he saw it, the unscratchable Mirage sample was heavily scratched. It was broken in two, and three shards of diamond glass were missing, which was really shocking for the Akhan CEO, and he contacted the FBI immediately. Next slide. Now we know that the relations between US and China are not so good, and when the FBI got to know that such incident happened with their fellow US company, they took immediate action. Things moved quickly, and Khan found himself on regular conference calls with officials from FBI and US Department of Justice. The FBI took the samples that were sent by Huawei and sent it to investigation. The gemologist said that he analyzed the diamond glass sample and concluded that Huawei had blasted it with a 100 kilowatt laser, which is powerful enough to be used as a weapon. When the Huawei engineer Angel Han were asked about the research that Huawei has done, she replied that she does not know about it, and she shipped the sample to Huawei and they took it to China, which was potentially a criminal violation of ITAR rules, which says that uh, which lists particular products can be only used in USA and cannot be shipped. So this was a criminal violation by Huawei of ITAR rules. Next slide. Then FBI decided to operate a sting operation in which they told that Khan will arrange a meeting with Han and they would be listening to it silently through earpieces. A Khan executed arrived in Las Vegas on Tuesday, January 8, and checked it at Mandalay Bay Resort and Casino. They arranged a meeting with Han and her colleague and the following afternoon at 3 p.m. Shubar bought signage to make it look like Khan had rented the space as Las Vegas Convention Center, where the CES conference was to be held. But the meeting was cancelled as at the last moment, Han said that she is busy and cannot and won't be able to come, and can only come after 2 or 3 hours. But there was a problem that FBI had rented the place only for 2 3 hours, so that the meeting was impossible to be held there. So they decided that the meeting will be held wherever the Han was staying, and they went to her place immediately. Now I'll ask Abhimanyu to discuss more about the conclusion that occurred from sting operation and what they received the information from it. Thanks.
Thank you, Aman, for presenting. As for the damage and next slide. As for the damage sample, Low claimed ignorance. She was trying to make sure that Huawei still had a shot at being the first company to put a diamond glass on their phone. When Akhan walked away, she announced that she may lose her job. When asked about the destruction of the sample, she claimed that she is not involved and cannot comment on this. The FBI raided the facility on January 28 morning. There, two special agents and a US Attorney Kessler briefed Khan about the scope of search warrant in vague terms and instructed Khan and Sherboff to have no further contact with Huawei. When Adam Khan's company and FBI conducted the sting operation, Huawei representatives admitted that to breaking contact with Akan Semiconductor and thus violating the US export control laws. Next slide. Huawei has such a bad past record, it is not a newbie in property theft. In 2002, Cisco Systems accused the company of stealing source code of its routers. Motorola also in 2010 claimed that Huawei had turned some of its Chinese-born employees into informants of the company. Finally, in 2012, the US Intelligence Committee labeled Huawei a national security threat and urged the government to not buy its products and also the companies to not interact with them. Huawei is trying to deny all the claims. The Cisco and Motorola lawsuits ended with settlements. The US Department also suspected Huawei of stealing trade secrets of T-Mobile pertaining to their touchscreen experience. Next slide. The US Department of Justice finally on January 28, 2019 charged Huawei with bank fraud and stealing trade secrets. In a 13-count indictment, Department of Justice charged Huawei with a laundry list of crimes, including conspiracy, money laundering, bank and wire fraud, and obstruction of justice. Huawei denied all the US charges and said that the US Department is not trying to contact with them and they have rejected their plea without any explanation. The company said the trade secret theft allegations were already the subject of a civil suit that was settled by the parties. Numerous countries also allege that the company's products contain security holes, which allow them to transfer data to Chinese government and also claim that Huawei steals some of their foreign technologies. Okay, now Dharmanshu will end the slide.
In the end, the FBI and US Department of Justice had labeled Huawei a national threat, and it was banned away for good. The Chinese has, however, denied this claim, and here is the screenshot which we have attached regarding their official website, which states that Huawei is in touch with the Iran, because there are also tensions going on between the US and the Iran, and US and North Korea, and it is helping them to get secret intelligent information for these two countries. And this is the world map on which Huawei has been banned or is on the verge of ban. US has completely banned Huawei, and it cannot trade any longer with the US or any of its company, whether it be Apple, Microsoft, or Google, because most of the phones, the Honor phones or Huawei phones which were sold in India, were based on Android, and now they were forced to develop their own Hongman OS. But it was a big blunder for Huawei, because Huawei had faced a lot because of this. There were revenue loss, and it was criticized heavily around. Instead, Huawei had managed to get back a chunk of the smartphone share in the industry, because in China, the other Google services are banned. Apple, the several of the Apple services are banned. YouTube, Instagram, Facebook, all these are banned. They have their own services, and most of them is controlled by Huawei. So still, Huawei controls the world's largest population country. So this was the end of our presentation. These are the references. So thank you.
Thank you. Good in depth in the term paper. And this Huawei is the largest PCT filing company in the world.
Yes, sir. It's also the largest patent, yes, sir, in the world.
Largest patent. If you remember, in my slide, I had shown this thing.
Yes, sir. There was a question in the minor also, I guess.
चलो ओके थैंक यू वेरी मच
Thank
सो
you, sir.
अच्छा नाउ व्हाट अबाउट द कितने लोग रह गए अभी यहाँ पे इस क्लास में बंद कर दो स्लाइड अपना हाउ मेनी आर लेफ्ट हियर नाउ
27 students
27 अच्छा तो ये बताओ कि व्हाट इज द नेक्स्ट वो फेस उसको जीआई का कब करना है जीआई शुड टेक मच लेसर टाइम
Yes, sir.
7 मिनट्स मैक्सिमम 1-2 मिनट बीच का लगता है तो 5 + 2 मिनट 7 मिनट्स क्विकली सारे वो फोटो वोटो दिखा के मतलब उसमें बहुत ज़्यादा टेक्निकलिटीज नहीं है तो एक आध केस में हो सकता है थोड़ा बासमती टाइप में बट ज़्यादा नहीं होगा तो क्विकली उनका दिखाने कर नेक्स्ट मंडे थर्सडे को दिवाली है so first I wish you all very very happy Diwali. Have a good festival celebrations and keep all safety measures. Let this Diwali meetings don't enhance COVID cases in Delhi and wherever you are. तो नेक्स्ट मंडे को उसका क्विकली कर देंगे हम presentations.
Yes, sir. But can we have that on Saturday? Like if we have only 2 classes remaining on Monday and Thursday, so it will be better for us to like on Monday on Thursday we will be clearing our doubts or maybe some topic if you have remaining, then we can learn.
I can suggest you one thing कि Thursday का class clarifications के लिए उस सबके लिए रख लो और मंडे को ही सारे वो हम कंप्लीट कर लेंगे शाम को बैठ जाएंगे दोबारा
सर मंडे को भी अगर क्लियर करेंगे तो अगर हम 5-5 मिनट भी ले रहे हैं तो यहाँ 30 ग्रुप्स हैं तो 30 ग्रुप्स के लिए कम से कम कितना मिनट हो गया 2.5 घंटे से 3 घंटे तो लग जाएंगे
हाँ तो 1.5 घंटा क्लास का अभी भी तो हमने आधा घंटा 45 मिनट ओवरशूट किया है ना तो उसी में थोड़ा सा ओवरशूट कर लेंगे और फिर कुछ बचेगा तो दोबारा 5, 6, 6:30 बजे दोबारा बैठ जाएंगे मंडे को क्लोज करेंगे सारा कंप्लीट ठीक
अच्छा सर ठीक
और
ठीक है
थर्सडे को क्लैरिफिकेशन
ओके सर ओके
चलो
ये .ppts फॉर्म में AI वाला भी प्रेजेंट
सर हम लोगों को जीआई वाला प्रेजेंटेशन सेंड करना होगा
सारी जानकारी भेजा नहीं है अभी तक
नहीं सर सर हम लोगों ने पीडीएफ में भेजा था फिर पीपीटी में शायद भेजना होगा
पीपीटी जो शुरू में in the beginning it was told कि you have to give it in the PPTX फॉर्म या इसका जो है docx फॉर्म?
Yes, sir, you said that, but when I asked Jason, sir, he told me to send it in PDF format, so I have sent it in PDF format.
नहीं, तो जो PDF तो बनाते बाद में ही करते हैं ना, एक ओरिजिनल तो होता है ना, तो
yes sir.
हाँ, तो फिर क्या दिक्कत है? एक मेल ही तो करना है ना, दोबारा कर दो मेल, ठीक है?
ओके सर, ओके
चलो क्लोज करें यहाँ से क्लास?
यस सर, वी कैन।
थैंक
यू सर।
चलो ओके, सबने सुना, अच्छा लगा, नॉलेज बढ़ी सबकी?
यस सर, यस।
चलो, that was the purpose. Okay, bye.
Thank you, sir. Bye.